about that, and it's okay, it's fine, that's why he changed the ID. So now they're changing that stamp. Before they will not do that. So that's a good thing. Also, they can deny you asylum because of changed country's condition. Let me go fast. The actions, the person who is being persecuted. I have to do this. I have to be too much. Well, the persecution by whom? You know, again, it cannot be like my clients. It cannot be your neighbors. It cannot be your brothers. You know, it has to be from the government of your native country. But there's an exception to that. There's a point when, if, let me say, the population or the local population tries to persecute you based on your what? Based on your race, based on your religion, based on your membership in a social organization or political opinion. If they want to do that and the government refuses to protect you or provide the protection, then the action can be seen as a government action. So you can use that to apply for asylum. But apart from that, you have to show who's doing this. It cannot just be a regular. It cannot just be a regular person. It has to be from the government, or the government fails to protect you from this person that's persecuting you. Another issue where they deny application asylum is when, if you, let's say from Nigeria, it's a big country, and you claim that you've been persecuted in the south or the north. If they can show that you can move to another part of your country and you be safe, they will deny you. They deny your application. So you have to show the court that there's a countrywide persecution of you based on your race and all that. Are you serious? Anyway, so I'm really sorry because it took me 30 minutes. I just rushed this. Well,
I apologize for that.
Consult your lawyer, for details, and you can call me and then we can discuss it. Thank you very much.
Thank you.
I will now call on Attorney Uchechi.
Can everybody hear me without the microphone?
Yes.
Okay, my name is Uchechi Chebu, and I am the owner and managing partner at the Mercy Law Firm, located in downtown Silver Spring. My practice areas are immigration, personal injury, accidents, family, and I will expand as time goes on. My topic for today is going to be deferred action for childhood arrivals, which I'm also going to be referring to as DACA. So I'm going to be using the term interchangeably. First and foremost, we're going to start off with some DACA history. DACA is a derivative of previously proposed DREAM Act. DREAM is an acronym for Development Relief Education for Alien Minors. And what it was legislation which was introduced in 2001, and it was supposed to be a pathway for certain types of illegal immigrants to possibly gain conditional permanent residency and possibly citizenship. It took several different forms, and it wasn't passed on a national level. It wasn't approved in either House or Senate. It wasn't signed into a law. So because of that, different states have taken it upon themselves to try to come up with different formats based on their own objectives. Moving forward, last year, on June 15, 2012, the Obama administration announced that it was going to stop deporting certain types of young illegal aliens and proposed something called deferred action for childhood arrivals, which would enable certain classifications of young people who are here illegally to have 2-year work authorization, hopefully extending to a more permanent status at the expiration of that time period. question is, what exactly does deferred action mean? Deferred means that though you're here on an illegal basis, the government may suspend taking the lawful steps within their power to remove you from this country pursuant to legislation. So it doesn't mean that if you are approved for DACA, it doesn't mean that you automatically are here legally. It just means that based on the 2-year work authorization that you're going to get from having a DACA approval, that you're able to stay here lawfully and have the benefits of being a recipient of DACA. The next question is, who is eligible for DACA relief? Amongst other requirements, you have to have been under 31 as of June 15, 2012, which is when Obama administration first announced it. You have to have come to the U.S. while under the age of 16. From June 15, 2007 to 2012, you have to have been here for 5 years on a continuous basis. There are some exceptions to that, which we're going to discuss a little later. You have to have entered into the U.S. without inspection before June 15, 2012, or your lawful immigration status has expired as of June 15, 2012. You have to have been physically present on June 15, 2012, and you have to have been physically present at the time that you're submitting your application, meaning you can't be in your native country and then have a family member submit your application on your behalf. You have to have been here as of June 15, 2012, and at the time that your application is being submitted. You have to either currently be in school or have graduated from high school or obtained a GED or have received an honorable discharge from the Coast Guard or Armed Forces. Another important thing, which is a recurrent theme today, you have to have not been convicted of a felony offense, a significant misdemeanor, or have received more than 3 misdemeanors, and you cannot pose a threat to national security or public safety. After you've submitted your DACA application, a few weeks later you're going to receive a call to go for biometrics, which is fingerprinting, and then you're going to go for a background check, and then after that you're going to receive notification as to whether or not your application is going to be moved on to the next step. The next question is, what is a significant misdemeanor? The Department of Homeland Security deems significant misdemeanors as any of the following: a burglary, domestic violence, sexual abuse or exploitation, unlawful possession of firearms, driving under the influence, and drug distribution or drug trafficking. In addition to any other misdemeanor, an applicant who was sentenced for more than 90 days for an offense will also have that classified as being a significant misdemeanor for the purposes of the DACA application. The next question is, how old do you have to be to apply for deferred action? In general, you need to be at least 15 years or older at the time you apply. The exceptions to this rule are that you're either in removal proceedings, you have a final order of deportation, or you have a voluntary order of departure. If you fall into those categories and you're not 15, then you can seek to have DACA applied to you. Unfortunately, if you are 31 years of age or older as of June 15, 2012, then you are not eligible to apply for DACA. The next question I have here is, what type of schools qualify under the Deferred Action Program? Public or private elementary schools, junior high schools, secondary schools, universities, or any other type of vocational programs. You know, there are people who, I've had clients who have called me and have asked if do their hairdressing or plumbing programs apply. Yes, you have to be in some kind of educational school program in order to apply. Another recurring thing that we've seen is whether or not a brief interruption in the requirement to have been here continuously from June 15, 2007 to July 15, 2012, is that going to affect your eligibility for deferred action? Now, if you were here but then took a brief absence to leave, or you went home, or you went on vacation for a few weeks, as long as you can determine that your intention is to be a United States resident, or your intention is to be based here rather than being somewhere else, then that should be fine. DACA is very, very new. Unfortunately, there haven't been any case law to challenge any of these requirements as of yet, so everything is kind of on an experimental basis. The most important thing is that you have to show that your intention is to be a U.S. resident. So if you left for 3 to 6 months and you were going as a result of establishing residence elsewhere, those are the kinds of things that are going to reduce the likelihood that your DACA application is going to be accepted. If you went to go care for a relative, or you were going home on any other type of temporary basis or business, then you can prove that though you left during that 5-year time period, your intention is to be based here in the United States. The other question I have here are, what are the forms that you're going to need to submit? Of course, you need to submit the actual DACA form, which is the I-821D. You have to submit the application for employment authorization, because the whole purpose of DACA is to enable young illegal immigrants the opportunity to work. And then you also have to submit an economic needs supplementary form, which you're going to have to kind of do a worksheet as to what are your expenses, what are the things that you're financially responsible for, in order to prove why you need to be eligible for DACA. You need to submit the $465 fee. That also includes the $85 biometrics fee. And you're also going to have to submit documentary evidence to explain away whether or not you don't fall into any of the other categories. Like I told you about the continuous presence. I had a client who came in, a native of Jamaica, and left for 2.5 months. What we had to do was submit an affidavit and other supplementary documents to explain away the fact that he left for so long. Luckily, he had receipts, another kind of evidence to prove that he had a sick relative that he had to take care of. So the reason why he couldn't come back as anticipated or earlier than the 3 months is because he had to take care of that person. But we're still waiting to hear back the result of that application, but there hasn't been any denial as of yet. The next question is, if you're granted deferred action, will you be entitled to work? Absolutely. That's the whole purpose of the deferred action for the 2-year work authorization. If you get it, you're supposed to be able to receive notification that you can take to any potential employer, and if you, provided that you satisfy what it is that they're looking for in the job, you'll be able to work like every other permanent resident or U.S. citizen in this country. If you're granted deferred action, does that mean you have acquired legal status? Absolutely not. Deferred action just means that, as I explained before, the government can suspend their constitutional right to remove you or institute removal proceedings. It just means what it is, nothing more, nothing less, that you have the opportunity to work for that time period, hoping that there will be some kind of an extension of that after the 2-year period, or that it is repealed and then something better comes up. But all you get in that DACA approval is the opportunity to work for those 2 years. If you're granted deferred action, can you travel outside the United States? This is kind of a tricky one. You can only travel outside of the U.S. After you have applied, paid the fee, received your notification that your application has been accepted, but you have to apply for advanced parole, meaning that you have to explain why it is, where it is that you're going to, and wait for them to give you feedback before you can leave the country. Now the problem is that it's normally only supposed to be granted for humanitarian reasons, educational or employment reasons. However, DACA is just an executive directive. It's not a national law, so it can actually be repealed at any time. If you happen to apply for advanced parole and be approved, you leave, it's repealed, don't expect to come back. So that's kind of the chance that you have to take. If a client came into my office, applied for DACA, and told me that they needed to leave the country, I would, advise them that it has to be kind of like a life or death situation, because if you leave before DACA is hopefully extended into something more, then you can jeopardize your chances of being coming back into the country. If your application is denied, that's it. You cannot file for an appeal. You have to apply again, or you can wait to see if the administration is going to do anything else or do something better. Now let's talk about some proposed benefits across the nation Obviously, you get the 2-year period of protection from deportation. You can work. Work permits, like I said, social security numbers in some instances, driver's licenses, possible travel permits, student loan aid, and the hope of becoming a legal resident many years down the road, or whenever and however and if ever, there should be something better than DACA. As I said earlier, because it's not national, different states have been free to adapt it however they want to, depending on their state constitution or any of the other specific state objectives. In Maryland has something whereby if you are authorized for DACA, if you attended a Maryland high school, then you can qualify for in-state tuition as long as your parents have paid taxes to the state governments. That's a plus. There's an article that I printed out this morning whereby, again, pursuant to the fact that states have the liberty to do what they want to do to it, in North Carolina, what they're debating is, if you're approved for DACA, you can have a driver's license that's going to have a pink band on it saying illegal immigrant or something along something along those lines, or no lawful status. So it's kind of like, it's a double-edged sword. You have your driver's license, but there's a pink band across it saying that you're illegal. So lots of people are, a little skeptical about that, because like I said, it's just a 2-year directive. We're not exactly sure where it's going to go. It's so new, it's not even a year yet. So if that's what you're stuck with after DACA has expired, and especially if there's no extension, if there's nothing better, there are some negative implications on that. Some other disadvantages is that the application fee is ginormous, almost $500, and we have to take into consideration the fact that these are illegal immigrants. Many of them are not authorized to work here legally, so depending on what type of job that they're doing, $500 is a lot of money to possibly risk having your application be denied, especially if there's no appeal process. You also have to provide sensitive and important confidential information about yourself, again, because it can be repealed at any time. There's no guarantee that it's going to be extended. Who knows what's going to happen to that information when the time period is up. However, the numbers have been encouraging thus far, entering into the 5th month. Of the nearly 1.8 million who are potentially eligible, nearly 368,000 have applied, and 103,000 of those individuals have been granted deferred action. So, and 157,000 of those applications are currently under review. So, that's in a nutshell. I hope you found it informative. Thank you.
Thank you. We will now welcome Attorney Isaac Falusi.
Good afternoon, everyone. My name is Isaac Falusi. I'm a partner with Lang & Falusi LLP. We are a law firm here in Maryland, Massachusetts, and Chicago. I'm not going to expand more on that because of time. We only have 10 minutes. Thank you, guys. They basically touch upon most of the, well, not most, but a lot of what you need to know. However, one thing that I want you guys to take away from here is, they were using a whole lot of term of art in law. When they say deportation, it means different things. When you say jail sentence, it means different things. When they say suspended sentence, it means different things. So you can't just like attach your English meaning to all these words. So I want you guys to understand that. What I want everyone to take away from here, most importantly, is this: that you must ask questions. You must ask questions all the time. Do it, and do it periodically. Like if you are undocumented status, or if you are basically an immigration system to normalize yourself, it is the most important thing you can do for yourself is ask questions. If you don't ask questions, you don't know. If you basically rely on what your friends or your dad that have gone through the same thing, if you rely on their information, you are doing yourself a disservice. It's not going to be completely helpful because things happen. And at the same time, immigration law is so vast. It's like Atlantic Ocean. How are you going to navigate it? You can't, so you need experts, basically. So do your research, ask questions periodically, maybe every 6 months, sit with an attorney that knows what they're doing, sit with them, even if you have to pay. Because the value that you're going to get from their information will be way more than how much you are paying, that you're paying those attorneys. So I'm basically talking about the policy and law in relation to immigration. But I'm gonna preface it with a story. 1985, this family came here from Russia. Father, mother, and 4 children. They came under J visa. J visa is an exchange visitor visa. Basically, what J visa is when you come to the country, there is an exchange of contract between the country you're coming from and the country that you're going to. Basically, so there is a whole lot of government exchanging relations going on there. And with J visa, you're basically subjected to 2-year foreign residence. And that foreign residence basically means that when you get into this country, right, and you're under J visa status, before you can get out of your J visa status, right, you have to go back to your country and live there for 2 years. It doesn't have to be your country, just get out of the United States. That is part of the rule. So, but if you do not want to do that, then what you can do is get a waiver from your country. Most things in life you can get a waiver for. So you can get a waiver from your country, and then you get a waiver with the entity that basically help you to get the J visa in America. So you can get a waiver here. So if you get those 2 waivers, then you can move your status from J visa status to whatever. But if you do not have that waiver, I'm sorry, there is nothing you could do. You cannot basically do anything. Even if you marry an American citizen, you find her or him, you fall in love and you marry them, nothing. You still have to go out. But now the problem is that if you have already overstayed your visa time, and you now take yourself and say you want to go out to your country or whatever country that you came from, guess what? That is self-deportation. A lot of people don't know, if you go out of this country yourself, that is self-deportation. And when you self-deported yourself, they count your ban, how long you're going to be away from the country that they won't let you come back. They count it by how long you are out of your visa status in America. So you may be bound for 3 years, you may take 10 years. So anyway, this family came here, great family. So when the father finished what he was here to do, he couldn't go back to Russia. There was a lot of stuff going on there, so it was basically, it would be a danger for him to go back. And at the same time, the children, they came here at a very young age, they already acclimatized with the American system. You can't take them out. So this is what this guy did. He was able to get Russia to waive, that 2-year foreign requirement. However, he couldn't get the school here that did the J visa with him to remove that waiver. It was and it's still the policy of that school not to give a visa waiver, the J visa waiver. So basically stuck. So he already went beyond the J visa the time that is allowed to be in the country. He couldn't go back. If he went back, that's deportation. It would be there. It wouldn't be able to come back. But over a 20-year period, this guy will go around and ask questions. If you're an immigrant, he will sit with you and ask questions. It will do his own research. It will meet with an attorney, pay them for 1 hour or 2 hours, sit with them, give the attorney all information. And if you give any attorney all your information, it's confidential. They cannot review that information to anyone. If they do, I'm telling you today, guys, if you spoke to an attorney and you found out that he was speaking about your information with them, he could lose his license. You just have to report him in whatever state you are. So we take that very serious. It's confidential, attorney-client privilege. So this guy will go around periodically. Periodically, he will keep asking what could be done. So basically the answers those people were giving him, they knew what they were doing. The attorneys that were giving him those answers, they knew what they were doing. But that was something they were overlooking. So I stumbled upon him one time. I was, I was at an event, so we stumbled upon each other and started talking. Oh, where you from? Oh, yeah, I've done something in your country before. You heard my accent. So we started talking, and he found out, oh, you're an attorney? Yeah. Oh, okay. So part of your practice is immigration? Yes, it is. So he started talking about, he didn't say it was him, but he started talking in third person. Right. So I was like, look, dude, get your friend and come and see me. Give my card, give my card. And he did, and in our cover, well, it was me, it wasn't my friend. I want to come, just come and sit with you. Blah, blah. So he came, very nice guy. His English is now way, way better, but at least you could understand what he was saying. So we sat down, we went over all the questions. He dug it out, everything. And so okay, the stuff that I was telling him was the stuff that he was already told by many different attorneys. So I was like, all right, but you have children, yes. And your children have J2. J2 is basically the dependence of the main J visa person. So I'm like, okay, you know what? If you couldn't get a waiver, if your school won't give you a waiver, how about we do a waiver for your children? So we tried it. And guess what? It worked. After 20 years. Guys, the only thing didn't work, at least 50% of the problem is solved. If the children didn't get the waiver, there is nothing they could do. They will have to go out, go to whatever. So, at the 20 years, different attorneys just keep talking and researching on his own. We were able to get the children off the waiver. So the point was, ask questions. You have to. It's so imperative. If you don't ask questions, sorry, you are going to have a hard time. If you're in this country undocumented, you will have a hard time if you aren't asking questions. You need to know where to place yourself. You need to know what to do, what state to live in. What state that you can live in that you'll be able at least to have a relatively good life as an undocumented. If you could not change, I'm saying.
Let's go to Arizona, right?
So, it brings me to policy and law. Basically, the difference between I'm sorry, I wasn't even, Basically, the difference between these two is policy is what the government chooses to do or not do. Their prerogative, okay? I want to do it, no, I don't want to do it. Law is what must be done or what must not be done. Law is usually in the books, it's from the United States Congress or in your various states, whatever Congress that you have. That must be done. Usually, policy usually becomes law. Policy usually becomes law. However, there are many times that we have policy, it existed and it died without becoming a law. So the example of a policy is what my sister just spoke about. The DACA that was signed, but it was a presidential directive August last year. That is the example of a policy. Basically, the reason for that is she was mentioning something. If candidate Romney had won the presidency, I'm sorry, DACA would have been scratched. So if you qualify for it, please take advantage of it for now. It doesn't really give you much, but at least it doesn't count against you that you've been here for extra 2 years. The 2 years that you're here with a granted DACA is basically good for you. At least it won't count against you when you apply for whatever later on in life. Example of a law is, I'm going to bring this to your attention. There is something that General Napolitano just signed in January. It's going to be in effect as of March. It's basically called I-601A. It's a provisional waiver for unlawful presence. Again, let me define something. There are many types of undocumented immigrants in this country. There are 3 types. There are people that came here actually there are 4 types. So there are people that came here legally. They got their visa, they got their visiting visa and whatever. They came into the country, but they overstayed whatever the visa they are in. Those people, yeah, if they met someone very nice and whatever, you could still change your visa status and legalize yourself. There are people that came under J that I just explained earlier. If you're under J and you didn't get any waiver, sorry, you're stuck. Most likely just remain on the, just remain. And now there are people that came through the border. They crossed the border, or they enter the port using somebody else's face. They use somebody else's passport. Basically, they call you Iwi, entrance without inspection. Iwi. Before now, if you are under that Iwi, there is nothing you could do to normalize yourself. Sorry, you have to go back to your country and try to enter back. And if you go back to your country by yourself, what happened?
You're stuck.
Thank you. Self-deportation. That's what it is.
Okay.
And then it counts against you. You might not be able to come back here in like 10 years. So there is this new law. Basically, now they let you apply if you enter the country. If you're like basically illegal and you enter the country illegally, not legally, illegally. Rather than going back to your country to apply for a waiver, they let you now apply for a waiver here. That is a new thing. So you need to take advantage of it. If you qualify, you apply for a waiver here. When you apply for that waiver, they basically just forgive you of that crime that you committed. So you're good. That is getting to me. So that's an example of a law. I hope you guys knew about that. Ask questions. This is a law. If Romney had won, Romney won't be able to change it. Basically, that was based on United States Congress statute that was passed. So that's an example of that. So, guys, ask questions is very, very important. There are states, when we talk about politics, there are states that are very friendly, very, very friendly to immigrants. There are states that are very, very harsh to immigrants. If you're an immigrant, if you're undocumented immigrant, there is no point living in Virginia. I'm sorry, anyone from Virginia? If you're on a undocumented status and you are living in Arizona, thank you, my brother, life will be so tough for you. But if you're undocumented immigrant and you're living in a state like, you're living in DC, that's okay. DC, you could get a driver license in DC without having to show that you are in this country legally. Maryland just changed that. Maryland used to be very, very nice, but now, for you to get a driver license, you have to show something more that shows that you are in this country legally. So, but you can basically do states like Massachusetts, states like Connecticut. Those states are friendly. So these are what we call, they have in their policy, it's not written down in any book anyway, but the way they execute their law. Basically, if you stole something in Massachusetts, right? If you stole something in Massachusetts, and the crime usually is a year. If Massachusetts, most likely, if you're an immigrant, and if you get a right attorney, another one thing I want to say is, if you get into trouble, please, if you're an undocumented, even if you're documented, as long as you're not a citizen, if you get in trouble, the very first person you should look for is immigration attorney. They know the consequence of whatever will happen in criminal law or civil law or whatever. Then let the criminal attorney, if he practices, like my sister, she practiced civil law, right, family law. So, I mean, if you do all the same thing in all the areas of law, that's good for you. So please, if anything happens, get immigration attorney first if you're a non-citizen, like my brother said. So one more, excuse me. This is very, very important. There is this policy being used by a score secured program by ICE. ICE are the people that come and take you and deport you. That's their job. So they have this policy. It's not a law. Again, so I'm just giving you guys the difference between these two. It's very, very vague, but the vagueness could basically come with a whole lot of ramifications to your situation. So this policy, what the ICE did, ICE is under Department of Homeland Security. What they're doing is have a database exchange program with all the states. Before, it wasn't like that. So if you are arrested, they find out your name is Kochiski something. You know, it's not from here. They put it in. Oh, this guy is undocumented alien. What they do is, basically, they will release you from there because for any crime you get a bail. So the state will let you go. Fine, hey, write your bail, but they will still